Thank you kindly. Again, we welcome you to the Massachusetts Appeals Court. For those of you who weren't on the video for our first hearing, my name is Judge Desmond. To my right is Judge Grant. To my left is Judge Hodgens. We'll be your panel for the remaining 5 cases in the morning. See some familiar faces. As you know, it's 15 minutes per side. There's no rebuttal. We've read your materials. We're familiar with the law. So you need not recite the facts. But again, of course, it's your 15 minutes to do with it what you will. That said, next matter is 2024 P0544, the Commonwealth versus Nicholls. And I believe this is the Commonwealth's appeal. Is that right? Attorney Baker.
Good morning. May it please the Court, Assistant District Attorney Lee Baker for the Commonwealth. I would like to use my time to focus in and address an argument in the defendant's brief with regard to the first issue. So, as you no doubt recall, the Commonwealth presented 2 claims of error. The first being that the motion judge had erred in finding that the inquiry should have ended when the defendant said that he was okay and had just been asleep. The second claim of error was that the judge improperly considered what she considered to be racial bias on the part of the officer in arriving at that conclusion. Now, I note that in the defendant's brief, the defendant takes the position that the commentary about Officer Hulting's potential racial bias was irrelevant to the decision. And it was, in fact, relegated to a footnote, two footnotes. But I would note that it is important where that footnote occurs. You know, it comes after saying that the inquiry should have stopped, and then there's this second footnote saying that the court has concerns about racial bias. Now, I take the defendant's position that it was irrelevant to the decision to itself be something of a tacit admission that it should be irrelevant.
If his actions at the end of the day were lawful, does it matter what his subjective intent was?
Right, it does not. That's the Commonwealth's position. And so I would agree that the big issue here is whether or not the judge was correct in finding that the inquiry should have ended when the defendant said that he was okay and was just asleep. Now, the defendant relies on Commonwealth versus King in support of his position. And I'm quoting here from, or rather the defendant does, I'm quoting from page 9 of the defendant's brief. As the Supreme Judicial Court held in King, we have no doubt that the trooper was permitted to ask for an explanation of the defendant's presence under the circumstances. The justification of his actions terminated, however, upon the driver's response. Now, taken alone, that seems to support the defendant's position. But I would suggest we have to really dig into the facts of King to see why it doesn't. So in King, what happened was that there was a policy that the state police had that during the winter months, during winter storms, they were to check the rest areas for parked vehicles to make sure that no one was asleep there, that nobody had abandoned a vehicle there, no one was in need of aid. And so the officer in King approaches this rest area, sees 2 vehicles there, one of which is a station wagon with 2 occupants. And the officer approaches, makes some inquiry. And as an interesting side note, there's a weird racial bias involved in that because the officer seems to be alerted to the vehicle by the fact that there was a white man and a black man together in that vehicle. It's strange, but not really super relevant here. Because what ends up happening is that the officer makes inquiry, asks for identification, so on and so forth. And it just keeps going.
This is in King you're talking about.
That's precisely. And so the court in King, there's the intervening factor that one of the defendants begins firing at the troopers. And so the fact that the inquiry should have ended when they answered his initial questions is the primary holding there, even though ultimately there's this intervening incident. And
Of course, in King,
yeah,
the cars were in a rest area where we'd expect cars to be for some period of time.
exactly. That's exactly where I was going. That's one fact that is very, very important. And there's language in King that is instructive here, where the court says in King, resting in a parked vehicle is the purpose for which highways provide a rest area. And that's clearly true. And the officer was acting pursuant to a policy, right? In theory, that officer should have checked every car at a rest area pursuant to that policy. So we're in a little bit of a different realm than we are in this case, or in Murdoch, which I'm going to suggest gives us more guidance here. Because in King, it's a pretty narrow holding, right? His justification, as it says in the defendant's brief, the justification of his actions terminated upon those response, because the justification of his actions was just to follow that policy and make sure the car hadn't been abandoned, that there wasn't someone in need of aid.
If instead of being parked at the pumps, the
Yes.
car had been parked in a parking spot in the gas station.
I think that's a difference that would make a difference, because that's part of where I was going, is to say that rest areas are for resting, gas pumps are not. And one would think that even if a traveler was tired, needed to just pull into the gas station and sleep for a while, they wouldn't park at a gas pump. So I'm suggesting that King does not get the defendant where he needs to be. And that what's more instructive here is to look at Murdoch. Now, in Murdoch, that's the case, again, at a rest area, but the facts are a bit different. The officer is alerted to that vehicle because as he approaches it, he notices that the brake lights are on, right? Which suggests that somebody has their foot on the brake, right? And he approaches, and there's a person passed out in that car. And he makes inquiry, and it's pretty obvious that this person is intoxicated because, according to the case, they doze off in the middle of the inquiry. So eventually they're taken out of the car, there are narcotics, and the trial court had allowed the motion to suppress in that case on the basis that even if there was an objective basis here for the inquiry, that the officer still had in his mind that this person might have been on a narcotics bender. And the court said that that's not relevant. What's relevant is the objective basis. And so I would suggest that what we have to look at here in order to determine whether or not that inquiry really should have terminated with the initial response from the defendant is...
I'm not sure what exactly that means. So in this case,
Yes,
we have the car, or at least the car's parked at the gas pump in an open gas station at 2 o'clock in the morning,
correct.
and the police come as a result of a call from the, I'm going to call them gas station attendants,
Correct.
who had tried to get some response from the
Yes.
people in the vehicle,
Right.
with no success.
Right.
So they called the police.
Right. And in fact, that car had been parked there from 2 a.m. to about 5:45.
So for a few hours.
Right,
At an open gas station.
Right.
When the police responded, they tried to make contact with both occupants of the vehicle.
Correct.
by knocking on the door, the windows of the
Yep.
the car.
Right.
And were unsuccessful.
Right.
Okay, so then what happened?
So then they open the vehicle, right?
They opened the driver's side door first?
They open both sides. So we've got an officer on either side, and they open both sides. And here's an important...
Both men wake up at that moment?
No. So what happens is then at that point, according to the testimony of Officer Hulting, and I can give you a site here. It was on page 19 of the transcript that he testified that at that point, they were yelling at the guys, "Are you okay? Are you okay?" So it's not simply a matter of they open the door, "Are you okay?" They open the door and they're yelling at them, "Are you okay? Are you okay?" before they begin to rouse, right? Another important fact, too, to consider here in the reasonableness of the inquiry is Officer Hulting also testified, and that's on page 28 of the transcript, that medical personnel were on their way at that point. Now, it's unclear whether the people who worked at the gas station had called an ambulance or if one of the officers had, but he testified that there were medical personnel on the way. He also testified...
Why is that important?
Why that's important, and it dovetails with the other fact that I was going to bring out, which is that he had training in wellness checks. And he testified that he was trying to ascertain whether or not these people were ill, overdosing. You've got medical personnel coming. You're a police officer. You're talking to these people who you had to open the door and yell at them to rouse them. They've said, "I'm okay, I'm only sleeping." But before you can make that call and say, "Don't bring the ambulance," it seems reasonable you want to make a little more inquiry, because I would suggest to you that if you find yourself passed out in a motor vehicle at a gas pump because you're overdosing, intoxicated, what have you, and you find yourself tired, if you find yourself suddenly in a position where a police officer two police officers are at the door of the vehicle, you're suddenly awake, and they're asking you if you're okay. If you are, assuming for the moment, for the sake of argument, if you are intoxicated or overdosing, probably your first response is going to be no, because you don't want to get in trouble. You've already trying to avoid...
Your response will be no or yes, that you're okay?
Right. No, you don't need help. Yes,
Oh,
you're okay. Right. Right. So I would suggest that this is a case where it really is simply a matter of what should a reasonable officer do in this situation.
So when they get them to respond,
Yes.
what happens?
So
They ask them, "Are you okay?" And they say, "Yeah, we're fine. We were sleeping."
Right. Right. And so the picture that I got, at least from the testimony, is you have Officer Hulting, he's at the door, he's got the door open, he's leaning in, he's making inquiry, he's getting that response. He says there's very little exchange beyond that initial response before he sees in plain view on the floor a firearm.
I don't know. Is that his testimony? Or was his testimony that the person in that seat started to become somewhat fidgety, and a little bit more
That's true.
aggravated?
Yep, that is true.
Okay, so what's going on during that period of time? That's what I want to know.
Right, right.
What's going on during that period of time?
Well, I think that you have a few seconds there, and that the officer is still active. Perhaps he becomes a little more suspicious at that point. Not necessarily that criminal activity is going on, but again, that this person is nervous because they're a drug addict passed out in a car, and now there's a police officer making inquiry.
Once the driver and the passenger say,
Yes.
"We're okay,
Right.
we're just sleeping,"
Right.
why can't the police officer just leave?
Well, he could, but he doesn't have to. And I would suggest he doesn't have to, and he really, and it's his duty to not at that point. Because again, this is different from King, right? Where he's not just, checking on a car, hey, are you okay? Are you okay? No, he's responding to a very unusual situation that I think that just based on common sense and life experience would suggest to you that something is going on with these
Well, isn't
individuals.
that exactly what happened in the Sargsian case, where didn't the driver wave off the police? But that wasn't the end of the inquiry, right?
I don't recall the precise facts of that case. I apologize.
So here, does the
Yes.
officer, is it fair for
Yes.
the officer to be reasonably satisfied with the answers that he's given? Or is he supposed to just accept the first answer that he's given and be on his way?
Well, I think that what he's doing at that point is he's acting pursuant to his community caretaking function. And so he has a duty to do more than just accept that initial answer. He has a duty to satisfy himself that there's not a medical emergency of some kind. Now, you could discredit the testimony.
Is it limited to just a medical emergency of some kind? I mean, here's an officer who gets called by the gas station attendants to come because we have a car, I'm not going to say suspicious, but we have a car that's been parked for a couple of hours at a pump, and we can't get anybody to wake up, and something's amiss. They don't know what it is.
Right.
And so the officer comes trying to figure out what that is, right?
Right.
And so is it permissible for them to try to ascertain exactly what's going on here?
Absolutely.
It's not a regular occurrence that you have both occupants completely passed out and non-responsive to a number of different efforts to wake them up.
Exactly. Yes.
So is it fair for the officer to kind of be wondering, are they overdosed? Is something else going on here? What's going on here?
Right. I think that it is entirely fair for them to have those concerns, even if, and there's no finding that this was the case, but even if in the back of his mind, in that split instance where there's the nervous, fidgety behavior, if in that brief second he also has in his mind, is there contraband in this car? Even if that, and nobody found that, but even if that were the case, it'd be like Murdoch, where the officer was concerned that this guy was on a narcotics bender. It doesn't matter. It doesn't matter if he also has that concern, as long as he's acting pursuant to that primary concern, which justifies the stop.
How long was the entire interaction before they were taken out of the car and arrested?
It's not clear how long it was, but the defense attorney did a very nice job on cross-examination of breaking down the steps piece by piece. And when you read that testimony, the cross, and you see each step, the impression one gets is this happens pretty rapidly.
I see that's your time.
Thank you.
Thank you. Attorney Howe?
Good morning, may it please the court. Caroline Howe on behalf of Mr. NAJAE Nicholls. So the motion judge here was correct that the initial stop was justified by the community caretaking exception to the warrant requirement, but it was also a seizure. Because the officer's concerns were fully answered by Mr. Nicholls, and because the officer didn't develop reasonable suspicion of any criminal activity while questioning Mr. Nicholls, the stop should have ended there.
So do you agree that these are pretty unusual facts? 2 in the morning, 2 people in a car parked at the pump of an open gas station for a number of hours and can't be awoken, get any response from them. Pretty unusual.
As somebody who doesn't regularly respond to these types of things, I don't know, but we do know that there are many cases we see in a community caretaking context.
Do you think that's a regular occurrence?
I don't think so, but I think that they were called in not because of a suspected overdose, but because they saw these folks sleeping.
And police officers, they're not obligated to check their common sense because they're police officers when they respond to incidents, are they?
Of course not. And I think that this officer was specifically trained in well-being checks. And I think that's...
But not just a well-being check. It goes beyond that. We're trying to figure out what's going on with two people parked at a pump. Maybe it's a well-being thing, maybe it's not. I don't know. Right?
Absolutely.
And the officers don't know, and the gas station attendants don't know.
Absolutely.
Right, so it's not limited to just a well-being check. Or is that your position? It is.
No, I think that you're right, that what the officers need to do is to ascertain the entire situation. So they arrive and they attempt to wake them up, and they can't, and so they open the car doors. And so our position is that that was justified under the community caretaking exception, but it was also a seizure because of the way that the officer was standing in front of Mr. Nicholls. Mr. Nicholls wasn't free to leave, and we know that from cases like Commonwealth v. Summerlin.
But they were asleep, right? So how would you be able to assess whether or not someone believed they were free to leave if they're just out? They're out cold, and someone opens the door. So they have no idea. How could that be a seizure?
So according to the findings of the court, they woke up when the car doors were opened. So now
Oh,
there's...
that's not the, okay, I thought the sequence was that they tried to arouse them, knocking, open the door, yelling at them, and then they were aroused. The door was already open. That's the way I read it, but
Okay,
you're saying it was a different sequence?
I think that's according to the testimony, according to the findings, that they opened the car door and then the two occupants woke up. So whether the officers were also yelling as they opened the car door, regardless, they opened the car door and the two occupants are awake.
So are you saying the seizure happened at the moment they opened the car door?
I think the moment that that Mr. Nicholls' path was blocked, he couldn't have gotten out of that car without physically pushing past the officer.
So when the car door is still closed and the officer's knocking on the window and yelling, that's a seizure?
No, I think we know from the cases that that is not a seizure. But once the car doors open and there's nowhere for Mr. Nicholls to go other than, into the path of the officer, at that point, it's a seizure. And again, we know that from cases, in contrast to cases like Commonwealth v. Sykes, where the officers are not restricting the defendant's movement. They're not blocking or impeding the defendant's path or direction or speed. I mean, here, obviously, Mr. Nicholls' path is blocked.
You raise an interesting point, and I kind of struggled with that as I read through the community caretaking cases. And as I read them, it almost seems like courts view it as is actually not a seizure if we're dealing with community caretaking. Am I reading that right?
I think that it's not always clear that the court is necessarily finding that there was a seizure, but I think here where the facts clearly show that there was a seizure, even though it was justified by the community caretaking exception, it is still a seizure, and as a result, it needs to be contained to the justification for the stop. And you can imagine there's many different cases where there's a community caretaking encounter that's happening on the street where the defendant is, or the person's free to leave, right? They can leave the encounter when they want to. And you can imagine that kind of encounter taking a longer time, the police officer kind of fully fleshing out the circumstances. But here, where it's a seizure, in the constitutional sense, there needs to be a limit in the scope of the stop to the justification for the stop. And so
maybe, I think the community caretaking doctrine permits some period of detention while they're trying to assess and figure out exactly what's going on here. So while you call it a seizure or not, the officers have some leeway in the community caretaking doctrine that allows them to just say, hey, hang on, I get to reasonably satisfy myself that everything's on the up and up and things are okay here. Do you agree with that?
absolutely.
Okay.
I think that's totally right. And I think we have to look at the objective, reasonable basis the officer has. And here they obviously do. These folks have been asleep for several hours and can't be woken up.
So is it your position that, and there might be some reasonable minds might differ about whether or not when they opened the door they completely woke up in that moment, or when they opened the doors they still had to make some efforts to get them to respond before they responded. But let's assume for the sake of discussion they open the doors and the officer says, what's going on here? He says, I'm fine. Is it your position that they needed to leave right then?
So it's two questions. It's not just, he says, are you okay? And then,
My
do you
question
need
to
medical
you
assistance?
is, let's assume the officers open the door, and he responds, and the officer says, what's going on here? And he says, I'm fine. Were the officers obligated to leave at that moment? That's my question.
So I think we need to look at all of the circumstances, because it's not just what the person is saying. I don't think that
You don't like the question that I'm asking?
I don't think that the officer needs to accept what the defendant says. I don't think that they need to take the defendant at their word. I don't think that he needed to say, oh, Mr. Nicholls says he's fine, so I have to leave.
Okay.
I think we have to look at all of the circumstances. So here we have not only Mr. Nicholls saying, I'm fine, I was asleep, I don't need medical attention, but we also have no testimony in the record that the officer continued to be concerned. He does not say, I was really concerned about his appearance, he looked really unwell. He doesn't say, I smelled drugs, I smelled alcohol. He doesn't say, I saw needles, I saw alcohol
So
cans.
what does happen? He says, I'm okay, and then what happens?
He says, I'm okay, I don't need any medical assistance. And then according to the record, we know that it then transitions into, I think, according to the testimony on page 20 of the transcript, a normal conversation where the officer is trying to figure out why they were asleep at the pump. And at that
Was
point,
that a normal conversation?
so I think it moves away from the community caretaking
Well, isn't that's why they're there.
concern.
We're trying to figure out why these people are asleep at the pump.
So I think that turns into investigation. And we know that community caretaking exception is actually a really limited one, because we're worried about the safety of an individual or the public being jeopardized,
Right.
and we're not worried about the detection, investigation, or acquisition of evidence. It's a really limited
I understand,
exception.
but my question is, could it arguably be a community caretaking? I'm concerned for the public, because I have these two men parked at a pump at 2 in the morning until 5 in the morning. That's unusual, and they're not responding, and I don't know what they're up to. And before I just let them go off into the public domain, I need to figure out what's going on here.
So I think that we know that according to his observations of Mr. Nicholls and Mr. Nicholls' responses, and the fact that there's no testimony that he continues to be concerned about Mr. Nicholls' welfare, right, that he's not concerned anymore about whether Mr. Nicholls is okay, whether he's overdosing. And we now have a situation where there's no reasonable suspicion that's developed of any criminal activity. We know that Mr. Nicholls is okay, and unlike most of the cases in the community caretaking context, Mr. Nicholls is not the driver of this car. So in a lot of these cases, we have a deep concern that not only is the person not okay, but also that they might be operating a vehicle.
Yeah, but again, just because someone says they're okay, I mean, I just think of human nature. How often does it happen where, you're walking along and you fall down the stairs and someone says, oh my God, are you okay? I'm okay, and it turns out, oh no, you actually have a broken ankle. I mean, human nature, you often will say, I'm okay, I'm all set, but maybe you're not. And I mean, what comes to mind for me is just, not necessarily an overdose, but just like carbon monoxide. I mean, you have two people who are knocked out in a car at a gas pump. It almost seems like whatever overcame them both very suddenly. And
So we
shouldn't
both-
there be some inquiry? And the other point, to make this a two-parter question, because you had mentioned conversation, that there was a conversation that followed when the defendant said, I'm all set. But the judge kind of drilled down on that, and it seemed to me that it really wasn't a conversation. It was really just one question. That, well, what are you guys doing here at the gas pump? I mean, that was kind of it. It really, and then he sees the gun on the floor. Am I correct on that?
I don't think so, only because I think the testimony was that he was trying to figure out what they were doing at the gas pump, and they were having a conversation. And so based on the officer's testimony to that effect, I do think that it was a more prolonged interaction rather than just one further question. And the judge's finding that they continued to speak, I think, speaks to that testimony, that it was more drawn out. But in terms of concerns about carbon monoxide and things like that, this is in a real, I think, sharp contrast to cases like Commonwealth v. Leonard, Commonwealth v. Murdo, where you see the officer has clear observations that immediately tip them off that the person's not okay. They see they're disheveled. They're responding in a really hostile tone. They smell alcohol, bloodshot eyes. These are really obvious, like the observations that they can make about the appearance, about the car, about the way the person is responding to them, that would make them concerned and want to continue that interaction. But
What
in
does the police officer do with the fact that it's 5:45 in the morning, this car is apparently blocking the gas pumps, the gas station is probably going to get busier
Yep.
than it was when they got there at 2 in the morning, the attendants are concerned enough that they're calling the police after almost 3 hours, almost 4 hours. Could the police officer call a tow truck?
I think so. Mr. Nicholls is the passenger of this car. So I think any conversation about the car needing to move along, that sort of stuff needs to be directed at the driver because he's the one who can move the car or, whether the car needs to be towed. We know from the cases that, that kind of inquiry is properly directed at the person who is in charge of the vehicle. But, going back to Commonwealth v. King, we know that where the person's answers are appropriate and where there's nothing else about the circumstances that would give the officer basis to continue to, have suspicion of criminal activity.
So let's pause there for a moment, if we may. Just because someone says it so doesn't necessarily make it so. And for me to ask, or for the officer to ask, are you okay? And that makes you fidgety and nervous. Doesn't the officer have some duty, some obligation to figure out why? That doesn't seem like the appropriate response to my question, if you're okay.
So I think the testimony is that he asks if he's all right, he asks if he needs medical attention, and then after, when he continues the conversation, that's when the nervousness develops.
You keep saying continued the conversation, so I'd like to know, what was the continued conversation? Tell me about that.
I think according to the testimony, it was a normal conversation, and it was the officer's attempt to figure out why they're at the gas pump.
Okay,
And
so
I think
that's fair, right?
Well, no, I think that in the community caretaking context, where there is both these statements by Mr. Nicholls that are appropriate and reasonable, and then we also have no other observation from the officer, no other concern expressed by the officer to the person's safety, no reasonable suspicion that's developed in that time.
So
because
are
it's
you
a
saying that
seizure.
the community caretaking is an appropriate concern of the police only if it's to do with the welfare of the passenger and the driver, but not if it's to do with why they're blocking the gas pump?
So I think the community caretaking exception specifically says an objectively reasonable basis for believing the safety of an individual or the public is jeopardized.
Community, right?
Mm-hmm. Right. And
So here, the officer is not reasonably satisfied. I mean, I think you just told me the conversation is he's still trying to figure out why are these guys parked at the pump? Mm-hmm. Isn't that what he's supposed to be doing?
I think in a normal encounter where he's not seized the people, yes.
I'm not sure when you say a normal encounter. These aren't normal facts. So I'm not sure when you say a normal encounter.
I suppose I should have phrased it better. An encounter where the person is not seized. You can imagine that's often what police are doing. They're interacting with members of the public out in the community, and those members of the public are not seized. And those encounters can carry on for much longer than in this context. But because Mr. Nicholls is seized, and because the justification for that seizure is this limited exception to the warrant requirement, it needs to end when that justification ends, just like in Commonwealth v. Tavares, when you pull over.
So when does the justification end? As soon as he says, I'm fine? Even if the officer is not convinced he's fine?
Where there is evidence in the record that the officer felt that he wasn't fine, or there's any objective basis for the officer to believe that he's not fine, again, we see in all these cases that the officer observes things about the defendant, about the surroundings, that make them have pause about.
So if you're fine, why are you parked here for 2 hours at an open gas station pump from 2 to 5 in the morning?
So I think he said he was...
Those two things kind of make sense?
I think the testimony is that he was asleep, but again...
They were both asleep.
They were both asleep. And so I think once he's ascertained that he is physically okay, he doesn't see anything else that gives him pause about the situation. And
Except the gun.
Which happens after, during that extended conversation. That is...
Extended. How long do you think the whole interaction was?
I don't think that
before they found the gun? How long do you think it was? 5 minutes, 10 minutes?
I don't think that we know from the testimony, but we do know that this conversation carried on after those community caretaking questions had been fully answered, and we know that the officer did not have any more concerns about Mr. Nicholls. I see my time has expired.
Any other questions?
No, thank you.
Thank you very much, Attorney Howe. The matter stands submitted. The next matter on our list is 24P0913, the Commonwealth versus Hancock. Attorney Osborne.
Good morning, Your Honors. My name is David Osborne, and I represent the defendant in this case, Theodore Hancock. Conveniently, we have a claim to address each of the three convictions against Mr. Hancock in this case. The first one I want to talk about is the malicious destruction of property conviction. And our claim is that the evidence was insufficient to prove an essential element of that case, of that conviction, which is maliciousness. Pardon?
The malice?
The malice, correct. And we know that I think it's undisputed that malice has a very specific meaning. It's not just the intent to injure the property. It's an intent effectively to injure the owner of the property.
So in this instance, we're talking about his kicking the door down to her house. Is that the?
That's correct. That is the only property destruction that we're talking about here. It's the kicking of the door. And even accepting all the inferences in the light most favorable to the Commonwealth, the evidence is not sufficient to prove that act of kicking the door was malicious. Because, again, it has to be, the courts have said that it requires a state of mind of cruelty, of hostility, or revenge.
Yeah, but in the context, though, I mean, the defendant was thrown out of this residence, and it seems a pretty short walk from there to you go back and you're kicking in someone's door. You're directing that at the person who threw you out, and it's to disturb her peace of mind in her home. It seems that it's pretty much directed at her.
Well, there's a problem with that, Your Honor, and that is what the Commonwealth says. The Commonwealth says, well, one evidence of malice is that Mr. Hancock was kicked out of the house. The problem with that claim, though, is that that's not in the record. There was testimony by the SB, I'll refer to her as SB, the ex-girlfriend, that she kicked him out of the house. But there was an objection by trial counsel. The judge sustained the objection and struck it and instructed the jury not to consider that testimony. What's striking about this case, because the Commonwealth knows it has to prove malice, what's striking about this case is that the Commonwealth presents no evidence whatsoever of the nature of their relationship. It doesn't present, there's no evidence about who broke up, who terminated the relationship, who kicked who out of the house, because that was excluded by the judge.
I understand, and I'm not sure why that might be important, and you'll tell me.
Well, the Commonwealth says it's important.
Hang on for a second.
Yeah, the Commonwealth says it's important.
So hang on for a second.
That's their evidence of malice.
Hang on means hang on.
Oh, I'm sorry.
Okay. Hostility. This wasn't a hostile encounter. We have the video. We've seen the video, right?
You have seen the video, Your Honor, but that is not the encounter that we're talking about.
That's
we're talking
after
about
he's
two
into the
encounters.
house. But the testimony, I thought, was this kind of back and forth while he's outside the door. I want to come in and get my TV. Go away. You can't come in and get me. I want to come in and I want to get my TV. Go away. My kids are here. Don't come in here.
Correct.
My kids are here. Go away. I'll bring you your TV tomorrow. And he kicks the door down and goes in and gets the TV. So that's the factual
Correct.
background, right?
That is
And you're
all
saying
correct.
that's not, there's no hostility there?
Yes, that is what I'm saying, Your Honor. There's not hostility. There's no evidence of, or you can't even infer evidence of hostility towards SB. The reason is because is because he's not yelling, he's not shouting at her. She testifies. She's asked the question by the district attorney, was he yelling? And she says, no, he was talking. He asked to get his TV set, and this is the important thing. Because I know it almost seems counter to logic, right? I understand why your honors are skeptical. It seems counter to logic. You kick in someone's door, hey, you know, it has to be a hostile act. But if you look at the cases where the courts have overturned a conviction for malicious destruction of property, it's the same thing. These defendants have kicked in a door, broken glass, because their objective
But
was...
one of the cases, he's trying to get away from some fleeing police. He doesn't even know who the homeowner is when he kicks in the door.
I don't think that matters, Your Honor. It doesn't matter if you know who the homeowner is or not. In fact, there's an interesting case
Well, if you don't
that
know him, how
we
can you
cite in our
know?
brief, the Armand case, where the person is trying to get into a car to beat up the occupant. Is that hostile? You'd think so, but the court reversed his conviction and said, no, the damage to the car was incidental to his objective of beating the occupant of the vehicle. And he wasn't attempting to damage the vehicle as a way of intimidating or overpowering the occupant. He just wanted to get into the vehicle to achieve his objective, which was to beat the occupant. That's pretty hostile, but in this case, that's not even what Mr. Hancock's objective was. His objective was to get his TV set.
Does
And
it
the door
matter?
was in
There's
the
an
way.
old case that defines malice as anger, hatred, and revenge. Does it matter? Does it matter if your client was angry at his ex-girlfriend because of their past relationship, or if he was angry at her because she wouldn't give him back his TV?
Well, he's not, there's no evidence that he's angry that she's not giving back his TV. If he breaks the door down because he's angry and he's like, I want to punish her, I want to make her feel intimidated, maybe, but there's no evidence of that. What happens is
What evidence more than kicking the door down?
he could be screaming at her. Here's another thing, Your Honor. He could walk in.
But he wasn't screaming at her. This is a domestic situation, is that fair to say?
Yes, it's two ex-partners, correct?
Right, so they had been in a relationship. Who knows who broke up with who and why, but we know that they had been in a relationship, and the relationship had recently ended. Is that fair to say?
That's all we know. The relationship ended. We don't know why, we don't know who. Could have been
And
amicable.
we know that he had
Could have
been
been
staying at
acrimonious.
her apartment for some time and had some belongings there. We know that, right?
Correct. That's correct.
And so what time of day is it when he's
This
out
is
there?
in the evening, I think about 6 to 7 o'clock, probably between 5 and 7 o'clock.
How would you characterize his behavior?
Characterize what, sir?
How would you characterize his behavior, Mr. Hancock? How would
His
you
behavior.
characterize
I think it was not, perhaps not prudent. I don't think that is the response that you would expect from
So that's
ordinarily.
what it's not. That's
But
what
that
it's
is
not. What
not-
do you think it is?
But that is not malice, Your
I
Honor.
understand. What do you think it is?
I think it is bad judgment. And by the way, Your Honor, there's another important thing. The Commonwealth says, you have to look at what the Commonwealth argues is the evidence of malice. It says, one thing it says is, well, okay, so she kicked him out, which we know that is not in the record. That's simply not true. She says she offered a non-confrontational alternative to getting his TV set by saying, I'll give it to you tomorrow. But you have to speculate about what that says about his state of mind. That may be reasonable to her, but to him, he wants his TV set, he's there. The third thing is
But
that...
wait a minute, okay, even if we accept all that you just said, is still the evidence that there were two doors. It was the outer door with the buzzer on it,
Yeah, that's right. It's because of the
and she was not letting him in, so someone clearly buzzed him in or whatever, or
presumably
walked
That's
through the
correct.
door and he just walked in the open door.
Yes.
So he's aware, and through he's aware that she's not being responsive to him coming in.
Right.
Right? But he goes in anyway. So, and then he gets to the second door, which is the actual door to her residence.
Yes.
and he kicks it in,
That's
destroying the frame.
That's
And
correct.
this wasn't just like shouldering the door in or something. I mean, it was destroyed.
Accepting the evidence in the light most favorable to the Commonwealth, because there was a dispute about that. Mr. Hancock's father testified that the door had been broken 2 weeks earlier. And that's an important point, Your Honor. One of the things that the Commonwealth says is, well, he kicked in the door before, and that shows that he knows what effect kicking a door would have. Well, I don't think he needed to do it twice to know what the effect of kicking a door would have. But the important thing about this is that which is why I think you can't infer malice. One reason why you can't infer malice is you've got a situation. You might think, well, this is crazy. You know, this guy kicks in the door because he wants his TV set. But we know, undisputed evidence, that 2 weeks earlier he kicked in the door because he locked his phone and keys in the apartment, which is again, this is why I say he's not exercising good judgment.
No,
but that incident had nothing to do with SB. It had nothing to do at all. It wasn't angry at her.
Was he angry about locking his keys in the house?
He wanted.
Angry
He
at her or
needed.
not, but was he angry about locking
Well,
the
we
keys?
don't know. We don't know if he was angry or he was just like, I'm a dope.
On malice.
It's not. It doesn't show malice. What it
I
shows
said,
is
no, I
that.
think we understand your argument on
Okay.
the element of malice. I see your time's running short.
Okay. Do you want me to move on to the next claim, Your Honor?
I think that's probably a good use of your time.
Okay, so the second claim is that is regarding the larceny conviction, which is, our claim is that Mr. Hancock was entitled to a defense, an instruction on an honest but mistaken belief defense.
That the phone was, now we're moving from the TV now to
Yes, the phone.
the iPhone, the
Correct.
cell phone of some
Correct.
sort.
This is essentially the second incident, right?
Okay.
And this was the trial counsel's entire defense. There was no other defense. It was undisputed that Mr. Hancock took the phone.
It does, but it does seem, I mean, having read the transcripts, it does seem like this, maybe he thought it was somebody else's, kind of came up in the closing argument.
Well, I disagree, Your Honor. There was actually, trial counsel elicited a number of pieces of information. And when you look at the totality of the information, I think it's clear that he met his burden. It's not a high burden, but he certainly met his burden, and it was clearly argued in closing. This was the defense on larceny. There was no other defense.
And so he reasonably believed that she was recording him with his own phone. What value would that have to her?
No, Your Honor, I want to address that because that was raised by, again, this was raised by the Commonwealth. This was the suggestion, but it's completely baseless. There was a recording, and you actually, Your Honors, have the recording. Yes, you have seen it. Right. And if you look at the recording, you'll notice a few things about it, important things. First of all,
Did notice
Mr. Hancock, well, okay, but I want to tell you what I noticed about it, Your Honor. What I noticed is that Mr. Hancock is in the hall when the recording starts. And he is rummaging around some boxes outside. He's looking for, and he says, I'm looking for my phone. Can you call my number? Wait, I just want to get through this, Your Honor.
My question is, are those the things that she had put in the hall?
Yes, I believe, I don't think it was testimony about what we were seeing, but I think you can assume that from the evidence that those were boxes that she'd placed out there. And in fact, what we learned on cross-examination was she put the phone in those boxes. But she doesn't tell him that. She doesn't say, your phone's in the box, leave me alone. She just says, I don't have your phone, and you can see that she's upset, she's screaming, understandably. But Mr. Hancock is quite calm through this whole thing. But he's in the hall when the recording starts. He walks in, you can see he's not even looking at her. And the phone drops. She doesn't say, I'm recording you, which is what you have to do if you want to avoid a wiretap problem, right? In Massachusetts, you need two-party consent. But she doesn't say, which is what people often do, say, I'm recording you. There's none of that. She's got the phone up, and then she puts it to the side. You can see the phone drops, and it goes upside down. She clearly just put it down to the side. So it's not like she's walking around following him, recording him. And I think that's a very important fact. So, and the Commonwealth says, well, her phone's an Apple, his phone's a Samsung, so how can you confuse that? Your Honors, this is a Samsung phone.
What do you do with the fact that the defendant didn't give pretrial notice under Rule 14
Yeah.
about this defense? Had they done so, the Commonwealth might have been prepared to describe more specifically what kind of a phone case she had on.
Well, Your Honor, the problem for the Commonwealth is that it's not required. There's no pretrial notice requirement. The pretrial notice requirement that is raised by the Commonwealth is Rule 14, Criminal Rule 14. It sets them out. And there's only 4 claims. There's license, there's claim of authority, there's claim of ownership, and there's exemption. I'm not talking about alibi or mental health defenses. Those other defenses, affirmative defenses, those are the only claims that require pretrial notice. And it's kind of obvious why, in a sense, Your Honor. It makes sense.
Is this a claim of ownership?
This is not a claim of ownership. Mr. Hancock is making the complete opposite claim. He's saying, I didn't own it. It was a mistake. Commonwealth, Mr. Hancock...
The argument was he reasonably believed that he owned the phone that he took, and therefore it couldn't be lost.
It was a mistake. He didn't own it. He's not claiming as a defense, I own that phone.
I thought he's claiming that he reasonably believed that that was his phone, and his taking it could not have been lost.
That is his claim. But that is not a claim of ownership. A claim of ownership, Your Honor, which is and the reporter's notes to Rule 14 explain what each of these claims are. And they say, a claim of ownership is an enforceable right to possession. There's no assertion at trial that this was his phone. He concedes, I took the wrong phone, but I didn't mean to deprive her of it. And in fact, it doesn't make any sense that he would take her phone, knowing that it was her phone, and not use it to find out where his phone was, because that's what he came in and he said, can you call my number so I can find my phone? He wanted his phone to ring. He doesn't do that. He apparently just walks away. He leaves with the phone. He believes the phone is his phone. He doesn't do anything that would suggest that he believes that it's her phone. It's quite
mistaken belief.
Illogical. Right. It's mistaken belief, Your Honor, which is completely different from the 4 types of affirmative defenses that you assert an affirmative right. I have a license. I have a license for a firearm. That's my defense. I was granted authority by the victim. The victim told me I could use the credit card. Those are affirmative claims. I have this right. That's my defense. He's saying, mea culpa. I screwed up. I shouldn't have taken the phone. But I honestly believe that.
I understand the argument. That's your time. Any other questions?
Thank you. Okay.
Thank you,
Your
Attorney
Honor.
Osborne. Attorney Johnson?
Good morning, and may it please the Court. My name is Melissa Johnson, Assistant District Attorney from Plymouth County on behalf of the Commonwealth. I want to first address where my brother left off with the Rule 14 notice of claim of ownership. Your Honor, Commonwealth versus Ryan and Commonwealth versus Vives, V-I-V-E-S, at footnote 4, completely contradict what my brother has been saying. Yes, you do need to give the Commonwealth notice of an affirmative defense of claim of ownership, even if it's based on an honest but mistaken belief. So yes, we were entitled to notice, and of course, as Justice Grant says, we probably would have tried the case a little bit differently had we known that was going to be the thrust of his defense, probably gotten a little bit more information about the phones themselves, what they look like, also some information about what the defendant said to the father when he gave him the phone, and of course, that testimony was cut off. But it's really neither here nor there. We're talking about a substantial risk of a miscarriage of justice. And the idea that this defendant actually thought this was his phone that the victim was using to record him is just preposterous. He never once said, hey, that's my phone, give it back, at all during this interaction whatsoever. We have her recording him. He clearly was upset about that. He's asking the daughters to call his phone so that he could hear it ring. So he clearly doesn't believe the phone that she has in her hand is actually his. So in terms of reviewing this for a substantial risk of a miscarriage of justice, whether he's entitled to that honest but mistaken belief instruction, there's simply not enough evidence to give that any kind of credibility, that claim.
Did he request that instruction, or was the judge supposed to sua sponte give that instruction?
Well, he should have first given notice to us, and that would have kind of started the ball rolling. But I do believe that he should have requested the instruction. Based on the evidence that had come in, there really wasn't any reason for it, and that's why we're here reviewing as a substantial risk. Could the judge have sua sponte given it? Certainly the judge could have brought that up and said, hey, I see some evidence here that maybe he mistook this. But really the thrust of the defendant's defense, and the closing argument was a little bit unclear because that's kind of the first time this sort of popped up. As I understood it, the defendant seemed to be saying in terms of the larceny conviction is, hey, well, I took her phone, but I didn't intend to permanently deprive her of it. I was going to give it to my father, and he was going to get it back to her. That seemed to be what he was saying, although obviously not very persuasive, but that seemed to be what his defense was to the larceny.
Father's an ex-police officer.
Yes. And he gave it to the father, and of course that conversation was cut off in testimony. I would have been interested to hear what the father said, what the defendant said when he gave it to the father. So that appeared to be the thrust of the defense on that particular count. And so for that reason, there was no substantial risk of a miscarriage of justice by not giving this particular instruction. The jury would have come out the same way on that particular count. In fact, they gave him a little bit of a break in coming down on the lesser included of larceny under versus larceny from a person. If there are any further questions on the larceny conviction, I'd like to turn back to the malicious destruction of property, and I think it's very difficult to really evaluate this in the light most favorable to the Commonwealth without looking at the context of the relationship here. All of the cases that the defendant has cited, in Woods and Redmond, all of those are cases where there's no connection whatsoever between the property owner and the defendant. The defendant just was fleeing the police and happened to bust in the door, or there was a robbery or a break-in. They wanted to get the computer equipment and happened to bust in the door and damage the door. So there was no relationship there, but here there is evidence of hostility between these parties. The victim is testifying she doesn't want this person to come into her apartment, specifically because she knows there's going to be an ugly confrontation and her daughters are present. So we know that this is not a...
What do you point to as evidence of hostility?
I point to the fact that the victim is testifying that she doesn't want him to come in because she thinks there's going to be a confrontation and her daughters are present. So I think there's an inference that there is not a positive relationship there. The fact that they had just broken up a week before, and she had taken his keys so he could not get in the house. The fact that she was trying to placate him by saying, look, I will give you back your TV tomorrow, just not now. My kids are in the house. So she is concerned, rightfully so as we find out, that there's going to be something violent happening if he gets into that apartment. And in fact, there was.
Did that happen, or did he just go in, grab his TV, and leave?
That's true. That is essentially what he did, but he could have waited till the next day. He didn't have to bust open the door. And that really is a sense of, look, I'm not listening to what you say to me. I'm overpowering you. I am claiming power here, and I'm going to bust into an apartment which he had no right to be in, take my TV, and leave. Okay, that, of course, the fact that he also wants his TV is not an antithesis to the fact that there's also hostility. It doesn't mean one cancels out the other. You can both be hostile and want your TV back, but it's the way that you're doing it that you are actually busting through the door and intimidating the property owner by doing so. So for that reasons, this is a required finding review here, taking things in the light most favorable to the Commonwealth. I don't need to try the case again necessarily, but I'm asking this court to take those inferences in favor of the Commonwealth on review. I do believe that there's enough here to prove malice.
I have a question for you about substantive dating relationship definition and the
Yes.
difference between how it's defined in 209A and how it's defined in 265-13M.
Yes.
In 209A, the last factor is if the relationship has been terminated by either person, the length of time elapsed since the termination. In 13M, there are two separate factors, whether the relationship was terminated by either person and the length of time. Is that a legislative typo?
Your Honor, I'm really glad that you brought that up, because I do agree with my brother. There's something not quite right about that definition in 13M subsection 3. It just doesn't make any sense that the termination and then the time elapsed by the from the termination would be separate factors. It doesn't make any sense. It's not, it should be the same as 209A, because if you think about it, the overarching element, these are just factors, the overarching element for a substantive dating relationship is have or are or have been. So you already have the fact that you could have a terminated relationship. And then these factors kind of leave you to define what they are. So it's almost like redundant that there would be this fourth factor. So to me, in my ideal scenario, I would have this court say, yes, the Commonwealth has shown that there's no substantial risk of a miscarriage of justice here, because clearly this dating relationship was not a contested issue. However, legislature, you do need to clarify this, because it's clearly, does not make sense. Now, in this case, the jury was instructed properly, and I don't think there's any substantial risk here. It's not a contested issue.
Ask a question about it, though.
There was a question about it, because I think that they may have just wanted to hear the overarching element, are or have been in a substantial dating relationship. So I think that, because I think the factors that the judge instructed on were absolutely correct. He kind of subsumed that fourth and fifth factor, just saying, the relationship was terminated, but you need to consider how much time has elapsed, essentially. So again, in my ideal scenario, this court would say, I agree with you, Commonwealth, there's no substantial risk here. However, legislature, you may want to tweak that a little bit to make it in conformity with 209A. And that's what I would request. If there are any further questions about it, I'd be happy to answer them. Otherwise, the rest of my brief.
Matter stand submitted. Thank you both.
Thank you.
Want to take a break? Want to take a break?
Up to you.
Take a 5-minute break. Let me see what you got. All right. Thank you. Give me 1 second. All rise. Thank you kindly.
Court is open. Please be seated.
We'll resume our hearings. The next matter on our docket is 24P0553, the Department of Children and Families and Another versus Mom and Another. Remind the panel parties that the case is impounded. Attorney Katz?
Good morning, Your Honors. Daniel Katz for the appellant mother, who is with me in the back of the courtroom with her case manager from a nonprofit that contracts with DMH. Thank you. This is a case which should be reversed and remanded by Your Honors, and I'd like to start with the first issue that this court should not give the usual deference that is accorded to a juvenile court judge in these types of cases. And the reason is because the judges of the juvenile court have certain mandates, and one of those is that the findings must be, not should be, but must be specific and detailed to show that close attention has been given to the evidence.
So here, mom's rights were not terminated, right?
Correct, Your
She was
Honor.
found unfit, but her rights were not terminated.
Correct, Your Honor.
Okay, go ahead.
The other mandate, not a should, but a must, is that the utmost care must be given to these proceedings. And normally, the deference is given to the juvenile court judge because the appellate court says, hello, Mr. or Mrs. Juvenile Court Judge, you're sitting there, you're able to judge the credibility of the witnesses and weigh the evidence. Here's the thing, Your Honors. In order to weigh the evidence, and if I could just ask you to imagine the Lady Justice with the scales of justice here, there has to be evidence to weigh. Yes, mother did testify, so of course the juvenile court judge is allowed to believe or not believe certain parts of her testimony. But the evidence has to be weighed so that this court knows that all relevant facts were considered. And how do we know that facts were considered, both positive and negative, about the mother and her parenting skills? We know because in the findings, the judge will make findings, and then we look in the conclusions of law, and then this court can assume, well, the judge must have considered X, which might be positive, Y negative, and decided, okay, I'm going to weigh this evidence. But here,
You think that the judge determined that she was mostly compliant with her action plan?
the judge definitely did mention that in terms of the positive evidence, and was correct in relying on the report of August 2023 and February of 2023, which said that, yes, mother specifically had been fully compliant with 6 of the 7 tasks. The one task that it didn't talk about was appearing in at court matters or foster care reviews. Prior reports did mention that. But what the judge didn't consider, and I say that because it's nowhere in the findings does the judge mention 3 pieces of documentary evidence that occurred after the incident in September of 2022 that led to the removal of the child.
That was the incident at the hospital, when they all went to the hospital. Right?
Yes, Your Honor.
Alcohol.
Right, yes, Your Honor. And so in the findings, there's no mention, and normally when I'm up here representing a parent, I'm trying to implore the judges to look at the evidence that the parent puts forth. And oftentimes, if the judge has considered it, the appeals court will rightly say, well, the judge went with the department's observations or take. But here, these three documents, the reports filed pursuant to 21A and I think the rule of juvenile court, Rule 10, and the family assessment were the department's documents. They were the department's evidence. Not only were they the department's evidence by the department workers, but they were issued post-September 20.
What were 1 and 2 again? I got the family assessment. What was 1 and 2?
So there was a family assessment dated July 2023, and I would like to apologize to your honors. In my pagination of the exhibits, I said that document starts on page 395 in the table of contents. I'm mistaken. I'm terribly sorry. It starts on page 389 of the exhibit volume. So I made a pagination error there, and I am truly sorry, but it is there for your honors to look at. That's the family assessment in July 2023. The other two exhibits are these progress reports that are, one is dated February 2023, and the other is dated August 2023. They are in the exhibit volume, and they are required to be issued by the department. And what I found, obviously I found it fascinating, but I'm hoping it will carry weight with your honors, is that the department workers specifically talk about her ability to connect with, bring out empathy for her daughter. And if we look at that, given the past trouble that mother had in dealing with the child's dysregulated behaviors, and then we have the incident in September 2022, but then...
Now, how do you know that the judge did not consider these documents? They were exhibits at the trial, right?
They were exhibits
available to the judge to consider.
They were exhibits at the trial, but I would ask your honor to consider this argument. If no finding of fact is made, because oftentimes we see in a judge's findings, they'll list positive evidence, they'll list negative evidence, they'll even mention, as did here, some testimony that mother made, and then the judge will say, I do not credit this, or I do credit that.
Which is often the case, but while that's true, judges are not obligated to talk about every piece of evidence that comes in a trial, right?
Correct, Your Honor. But then how does this court honor the SJC's mandate that the judge must weigh the evidence? Because otherwise, if there is no mention in a finding, then I fear that this gives the juvenile court judges free rein with no oversight by your honors. And all it takes is a simple written finding.
But aren't you reducing judges, though, to sort of the role of like being a scrivener or a, and not to disparage anyone's role, but to being like a stenographer, where you're just sort of recounting what evidence came in? I mean, do we really need judges to do that? Don't we have a list of that? We have a list of exhibits, so we know what evidence was before the judge. Is it really necessary for the judge to say, oh, there was also evidence of A, B, and C?
They are required because the SJC also says the judges are required to look at positive gains. Therefore, these three documents, which I hope your honors will look at, and I trust, and thank you, you will, were issued after this unfortunate incident in September 22, and how else can we determine that the judge is not allowed to completely ignore? And we know that famous quote from many years ago, the SJC saying, troublesome facts must be faced. Well, bingo, here are the troublesome facts written by the department, which are both positive about mother's insight into her ability, even with the past struggles with her child and the September 20.
No, go ahead, I'm listening. When you say her insight into her ability, speak more to that, please.
Okay. Your Honor, I wish those reports had given me, and therefore, Your Honors, more detail. Because yes, insight is a vague word, but sorry.
Go ahead, I'm listening to you.
Okay.
I asked you a question.
Yeah,
I want to give you the opportunity to answer it.
But what it does show, and especially when the department uses the word empathy, and I have to say, in my many years of representing both children and parents, that is a beautiful word, and I have very rarely seen that word used to describe.
I think the primary concern of the court was mom's ability to protect the child. Not that she was not empathetic, but that she was concerned about her ability to keep the child safe based on some of the conduct that they had engaged in, whether it was playing with alcohol or mom's drinking or whatever else, and subjecting the child to other outside forces to some degree.
Yes, Your Honor, and the judge, of course, was perfectly allowed to rely on her testimony when she, on direct, was essentially reciting her same safety plan that was in place prior to September 22nd. But if Your Honors will look at the transcript, which is not long, on when her attorney asked her, well, would you call the police next time? And she said yes. That was an issue on September 22nd because she did not call the police. So that was an addition to her safety plan. But the thing is that the comments that I wish I could recite to you from memory that were written in both the family assessment and the 21A reports, I think speak to Your Honor's concern about insight. I wish there were more detail. Insight meaning ability to gauge the situation with the child, therefore protect better than she had done in the past. And I don't think that's reading too much, given the high praise that the department's workers are actually putting in writing, submitting to the court. And I fear that the fact that they're not mentioned at all means that the judge missed one of the mandates of the SJC, which says if you don't write specific and detailed findings, face troublesome facts which are presented against the opinion that you're writing, then this court does not have to, or I should implore you to say, should not give the deference, and therefore this court should look at those documents and say, hey, we don't, in this case, we don't have to give the substantial deference because the mandates that the SJC said for a judge in reviewing, given the fact that the SJC has also said that the clear and convincing evidence standard is a heavy burden.
I have a question, sorry.
Sorry.
So fact finding 40, the judge said, mother's plan to ensure the child's safety if reunified includes putting cameras in the home, not having any boyfriends, and not taking her daughter anywhere with adults. As I understand it, the child is now almost 15, and the mother's plan for her safety is this. the family assessment talks about there being a high need for the mother to ensure her safety. And as I understand your argument, it's that because the judge didn't also quote that the mother has empathy for the child, that we should say this finding is clearly erroneous or an abuse of discretion?
No, I'm not saying that that finding is clearly erroneous. What I'm saying is that because the failure of the judge to follow the mandates of the highest court of Massachusetts in terms of written findings, this court should not give the usual deference
Okay,
to the judge.
we understand. So,
Okay.
Even aside from what deference we may give to the judge,
Right.
I mean, looking at the record itself, I mean, clearly the judge didn't terminate her rights.
No, because, I mean, yes, correct, Your Honor, department, and I don't have the answer why they didn't ask for that. Normally in these types of cases, we do see, you know, the next step being sought and often
I mean, it's a difficult case. I mean, the child has some mental health issues, mom has some mental health issues, neither should be faulted for that, but that's the reality of the facts that we have before us, right?
Right, you're correct, Your Honor, but I think the fact that that at the time, given, and I am hung up on this empathy word because I think that bears relevance to an ability to ensure safety, and the fact that
But couldn't it also mean that the mother identifies with the teenager so much that she gives her alcohol because she wants to be her friend?
Let me suggest another interpretation as my time winds down, is that it's mentioned in those reports, which I hope.
Yeah, you're over your time,
Oh.
but go ahead.
Oh, okay, sorry. Just mention briefly that it also mentions the empathy related to how the child can deal with her behaviors and her behavior specifically at school and in her foster placement. So I think that ties into that. Thank you. Oh, unless.
Thank you.
Thank you,
Thank you.
appreciate it, Attorney Katz. And I understand that child and the department are going to split their time. Is it Attorney Gilchrist going to go first?
Yes, Your Honor. Good morning, Your Honors. Attorney Claire Gilchrist for the Department of Children and Families. May it please the Court. We're asking you to affirm the order of the lower court today. This is a difficult case, as Your Honor mentioned, with mental health difficulties, both mother and child. It's clear mother cares deeply about her child and that they have a loving relationship. The judge recognized this in her decision. However, there was clear and convincing evidence here that mother was unable to meet the specialized needs of her child. Beginning when the child is 9, she's having suicidal statements. At the age of 10, she's engaging in self-harm. Mother left her unsupervised at home with knives in the home, despite recommendations from the daughter's care team. Fast forward a year, and so the department begins working with the family. Doesn't move to remove right away, is trying to work with the family, but around a year later, another series of reports come in. Mother and child are both hospitalized, and so removal is necessary. Mother's not able to sign for the child's care. So, and then we see that the judge does credit the positives. Mother, in conclusions of law 311 and 14, the judge finds that, mother cooperated with the department, she engaged in her action plan, she visited with the child, and those visits went well. The department attempted to reunify and place the child back with mother, and within 5 weeks, we have a very serious incident where mother supplies the child with alcohol and supplies her minor friend as well. Child is 12 years old at this time, brings her to an adult party, leaves her alone, and then we have these credible
allegations of sexual assault at that party.
What do you say to the argument of the mother that the judge's findings don't reference empathy?
I would say that, you know, that was one part of that July 2023 assessment. I mean, there's certainly some alarming parts that are against mother that the judge didn't cite to either. That doesn't mean she didn't read the assessment, but if you look at the July 23 assessment and you read all of it, you'll see that the department found that mother rarely, if ever, provides for the needs of the child, despite past difficulties. That's a pretty damning statement there. So we don't have any indication that the judge disregarded pieces of evidence. She does, in her findings, cite to events that occurred, you know, February 2023, finding 47. So she clearly is reading the reports of the department that were submitted into evidence. And we have custody of Eleanor, and we know that judges don't need to cite to every piece of evidence. But globally, the judge, you know, did credit mother for all the positives. But she found that despite that, that mother was not able to protect the child from harm, whether that was sexual assault or risk of self-harm. And her child continued to have these suicidal thoughts into 2023, just 6 months before trial. You know, the child was hospitalized and had picked a date to end her life. So these are really ongoing needs that the child had all the way up to the time of trial. And then we have mother's own testimony at trial where she, you know, the judge credited mother's testimony that she would have the same, essentially the same plan that had failed in the past. And also mother's testimony that she, although she believed that her daughter's claim that her boyfriend had made sexual advances towards her, she remained with this boyfriend. She'd been with this boyfriend for 2 years at the time of trial, and the judge didn't credit that she would simply not allow the boyfriend in the house. So those were credibility determinations that the judge made based on her observations. There's no reason to disturb those. And again, it's not a termination. Mother certainly has a right every 6 months to review and redetermination. And we do see in cases with children who are a little older that the department doesn't necessarily seek termination, you know, especially when the child can be placed with family and then there's still a connection.
Is that still the plan, that the child might be placed with family in Pennsylvania?
Your Honor, if I may go outside the record to answer that? Or?
Sure.
I'm sorry?
Sure.
She is now placed with family in Pennsylvania. If there are no further questions, Your Honor.
Hearing none. Thank you kindly.
Thank you.
Attorney Anderson.
May it please the court, my name is Scott Anderson. I represent the child in this case. We ask that you affirm the lower court decision. I'm going to tread lightly on these facts because my understanding is both parties are viewing this. But I would like to first point out that by my count, the findings of fact cite and incorporate 35 exhibits from the trial. So as far as paying attention to the record, I think that speaks for itself. And in addition, I would ask you to take into account the transcript appendix, particularly pages 156 and 157. That is mother's account of what happened on June 13th, 2022. Again, I'm trying to tread lightly on the details, but you know, that was the warning sign that there were problems with her ability to protect the child. That problem was not alleviated over the 2 years at the time of trial. And so when you look at that, the issue of credibility is the central issue in this case. The mother's credibility as to whether things will get better, her promises of a plan and so forth. But when you look at what happened June 13th, 2022, when you look at what she says on October 31st, 2023 at trial, 19 months later and nothing has changed, that speaks for itself, we would argue. And to finish, I would like to speak about the case adoption of Rona, just to avoid details. I think that'll make the point without talking about the record. Two issues. The first is Rona stands for the proposition that we ought to be giving deference to the assessment of credibility that the lower court judge gave. And I think if you look at findings 37, 38, 39, 40, she is paying special attention to the testimony of mother. And that is central to the decision, and I hope that we can take that into account. But secondly, interestingly, it's referred to as Rona 1 in the appellant's brief. That is a strong case for what happened in this case. That is, we have the parent on the stand presenting contemporaneously the situation. Are they presently able to perform? In Rona, that was reversed because the judge overlooked the mother testifying there, giving testimony that tended to show that she was sober, and ignored that and went 4 years back to look at the reports from when she was under substance abuse. So here we have the mother on the stand saying things that you will find on page 156, 157, and we're being asked to not look at what mother's saying on the stand in her present condition, but go back to what a social worker comments in prior reports. So I would ask a second look at Rona and how that impacts how this case should be looked upon. And we hope that you agree with us and the department and the lower court that my client deserves a chance at a fresh start. And I would like to rest on the brief.
Hearing no further questions, the matter stands submitted.
Thank you.
Certainly, one of the takeaways is there's no question that mom loves the child, so we'll leave it at that. The next matter on our docket is 23P1376, also partially impounded. John Doe, number 250253, versus the Sex Offender Registry Board. Attorney Burkholder.
Good morning. Good afternoon, Your Honors. May it please the Court. Attorney Fred Burkholder for John Doe. My brief is pretty self-explanatory, and ironically, my brother and I have been speaking about this case this morning, and what doesn't make any sense to us is counsel for Doe does a fairly decent job. I'd say actually a good job at the hearing. Submits the number of studies that are necessary, writes a very good proposed finding of fact and conclusions of law, seems to highlight the issue, and then the case gets to the Superior Court, and we don't know what happened. And I'm going to tell you, this isn't the only case where this occurred. I approached counsel and said, can you please explain it? I mean, I've got to try to justify what happened here, and I didn't get an answer that was satisfactory.
This business about it's not the only case where this occurred, is that in the record?
No.
Okay, so let's
No.
state of the record.
All right. So what doesn't make any sense is why that level of performance occurred at that level at Superior Court. I don't think there should be any question that that's a violation of the first prong of the ineffective the counsel test
What are
under
you
Superior.
pointing to specifically?
What am I pointing to specifically?
Yes.
Failure to challenge the application of factor 37 with regards to consideration of the two studies which were submitted by him at his his exhibits 5 and 6, which subsequent to his filing, but before his motion for memorandum in support was due, Doe 39239-639 is decided on February 1st, 2023, and addresses those very studies, those two, which he even highlights in his proposed finding of fact conclusions of law, which the hearing examiner made no mention of, let alone considered. So, a panel of this court says you got to look at those studies. They weren't looked at. He should have had awareness of this if he was, following what the decisions are, and he didn't do so. And this case was remanded. That's all I want.
What's that?
That's all I want. Same thing that happened in this case, same studies were involved, same lack of consideration, and same thing occurred here. Only difference is, this case, here it was raised in this court, whereas before it was raised by a motion, and I just checked before I stood up here. I was appointed on November the 20th of 2023, and after speaking with counsel and realizing I had no affidavit that generally needs to accompany a motion for leave, and then of course a motion to vacate, and that it's so blatantly clear, and there's a decision that's right on point, the very same studies, the very same issue, and the very same result, that under Zinsser, I thought the basis was indisputable on the record. Hence, here's where we are.
Anything additionally?
No, Your Honor.
Any questions? No. Thank you kindly, Attorney Burkholder.
If it pleases the court, David Chennai for the board. The board's position in this matter is that the counsel was not ineffective. I agree that a one-page memorandum was probably not the best advice, but he got out the message he was trying to get in that memorandum, which is his whole strategy from the very beginning is that this individual's health and deteriorating health is what lowered his risk to reoffend. And although we don't have a transcript of the Superior Court argument, I think it can be presumed that's what he argued in the Superior Court, judging from the Superior Court's decision. So the board's position is that even if that was below the standard of a fallible attorney, which the board isn't conceding that point, there's no evidence that better work by the attorney would have resulted in a better result for the offender in this case. So unless there's specific questions, I'd be more than happy to rest on my brief. I do have one point, though, Justice Grant. We had that argument last month about Factor 37 and repetitive behavior, and I have a case that I'm writing a brief on that is going to be all-encompassing on this matter, that when it's submitted, I'd be more than happy if I give you the docket if you could somehow get on that case and we can have the argument again. In fact, bring Justice Rubin and we can vigorously hash out that issue one more time. Only this time I'll be better prepared because I'm writing an epic tome on this issue alone.
Those says that the hearing examiner should have I just lost my train of thought for a moment. Considered whether or not Doe had engaged in any treatment, right?
Correct.
But Doe didn't, whether he was willing to or not. At bottom, Doe hadn't
Correct.
been involved in any treatment.
Correct.
So was that a wrong application of that factor?
No, because the factor specifically says someone who's terminated or refuses treatment is at a higher risk. That's what Factor 29, that's factor 32 says. And in this case, although he asked to go to a facility where he could do sex offender treatment, within months of getting there, he refused treatment and continued to refuse treatment, and 6 years later was denied parole because he wouldn't do treatment. So I think that it's clear on the record he refused treatment.
Thank you.
Thank you.
Matter stand submitted. The final matter on our docket is 24P0319, the Brockton Redevelopment Authority versus the Massachusetts Department of Housing and Community, and another.
Not very often that you see a case that finishes so different from the amount of time that was allotted it. May it please the court. My name is Sander Reclean. I represent the Brockton Redevelopment Authority. This is a case involving relocation benefits following an eminent domain taking. It's not disputed that Brockton Furniture, the displaced business, was entitled to relocation benefits. They were actually paid a very substantial sum for relocation benefits.
Is it disputed that they actually, no, so for starters, we're talking about a, was it an 8-story building that the furniture company was in?
Approximately.
With no elevator?
Broken elevator.
Broken elevator.
So they had to do it by the staircase.
And some fairly fragile pieces, as I understand, the furniture itself.
The owner was concerned about the furniture, and he wrapped it, and but of interest, although there were insured movers who had provided quotes, he didn't. His testimony was he didn't trust them, and so he hired day laborers.
Well, he didn't trust the low bidders.
I mean, he could have picked
He
the
probably
high bidder.
trusted Gentle Giant.
He didn't choose any of the movers. He elected to hire day laborers, and his testimony was that he paid them in cash. He didn't know their names. He kept no records.
I understand. So I start with, is there any question that the stuff was moved?
Oh, it was moved.
Okay, so somebody,
and they received,
somebody did it. Somebody moved the things, right?
and they received a relocation benefit of slightly in excess of $220,000.
What were the 4 quotes?
All of the quotes, I haven't looked at them recently. All of the quotes were 2-part moves. At the time the quotes came in, he hadn't identified a location. And so the quotes were to move him into storage, store it for a while, and then move him out of storage. Triple M, which was the lowest one, was for a 2-part move, was somewhat more than he claimed he had spent, and the other 2 were higher than that.
Okay. And so his figure was a reasonable figure. He actually worked with I forget what you call the...
There was a relocation
team
consultant.
of 2 who helped come up with the figures and give him some instruction on how to go about it. Is that fair to say?
Completely a calculated number. And our concern in this case is not that Brockton Furniture should get a payment. They did. They got a very substantial payment. Our concern is they kept no documentation. They had their own lawyer.
They had some documentation.
They had very limited documentation, and of critical importance on the day laborers. Although Mr. Abdelmonem testified that he went to the bank to withdraw the money, he didn't even provide the bank records. He provided nothing at all.
So was the concern that they did it for free?
Oh, no, nobody suggests they did it for free. But he testified that the move took 3 months. The claim form, which is in the record, page 74, the claim form says the move was from February to October, somewhat in excess of 9 months. And the numbers that they used to back into the calculation, that calculation appears in my brief at page 29, and if you do the math with the number of workers he said he had and how long they were working each day and that sort of thing, the math comes to in excess of 10 months of a move. But his testimony was it was a 3-month move. And our problem here, our problem from the first day, was we were concerned that he was seeking to profit from the move, not to be reimbursed for what he actually spent. And that is why you require documentation. And it's not Brockton Furniture's request.
But let me ask you this, though, that the statute doesn't require documentation, right? Doesn't the statute just require fair and reasonable relocation payments? Shouldn't that control?
The statute requires actual reasonable expenses. That's in section 7.IA3. All of those citations appear at pages 18 and 19 of my brief.
Actual, but there's no reference to documents in the statute. Right?
In section 14, 70A, section 14 requires actual reasonable documented expenses, and the requirement for documentation appears in a number of locations in the Bureau of Relocation's regulations. That's 760 CMR section 27 in .014, it requires documented expenses. In 27.04...
So why isn't the backup memo that was Exhibit 15, why isn't that documentation?
It was created after the fact as a justification for the size of the claim. That's
so your
different.
view is that documented in the statute means contemporaneous receipts?
In the regulation, no, the statute doesn't say that. In the regulation, 760 CMR 27.044I, it says, shall be support, I'm now quoting, but you can also find it in my brief at page 19 and in the addendum to my brief.
What if Mr. Abdul-Monem had kept receipts of the workers, but they were destroyed in a fire before he could submit his claim?
My simplest answer would be his testimony was that he went to the bank to withdraw the cash. So you produce the bank record, even if all of your records were destroyed.
Yeah, but they found that credible, right? They found that credible. They believed him when he said that.
The Bureau accepted his testimony, and I didn't challenge his testimony that he said, I went to the bank and I got the cash. I believe that he went to the bank and he got the cash and he paid day laborers. The question isn't, did he pay somebody to do the work? He clearly did. The question is, how much was paid, and the documentation that was available when throughout this process in front of Brockton Redevelopment. The documentation that was available were bank records, even if he had nothing else.
Was the figure just way out in left park? I mean, was the figure a reasonable figure? I mean, how did the figure, he took the average of the 4 bids, right? Or the 4 quotes, is that right? And how did he get those quotes? Those were through folks who the authority had appointed to be kind of the liaison or to assist him.
The authority had a relocation consultant, and Abdul-Monem had one, and the relocation consultants went out to try to get bids. At that point, they weren't sure where he was going to move, but you got to get the stuff out of the building.
Did the authority have any obligation to tell them about what's involved with self-help moves and to guide them along the way, and did that happen?
Number one, it happened to the extent that the Bureau required in its decision that we were required to tell them that he had to keep receipts for everything. No, he wasn't told he had to keep receipts for everything. He was given copies of the relevant statutes supporting information. He had a relocation consultant, and the Bureau, Brockton Redevelopment. This is a
furniture salesman, right? This is a furniture salesman we're talking about.
There were 2 relocation specialists involved, one for Brockton and one for Mr. Abdelmonum, and they were in constant.
I think Justice Desmond's point is Brockton Furniture is in the business of selling furniture.
It is.
And they move furniture
They
as
did.
part of their business. So it's not like they're selling widgets.
We concede they moved the furniture. It's not in the building. The building's been redeveloped and reopened. The question is, are they profiting from having failed to produce records by doing an after-the-fact calculation? Have they provided what the statute and the regulations require, which is documentation?
What do we do with the fact that Mr. Malika testified that in practice, self-move negotiations are not always put in writing?
All I can say is the Bureau has regulations. The Bureau is required to follow its regulations. I was in regular contact with Brockton Redevelopment, in which I would have the regulations open. I would review with them what the requirements are. They had their own specialist.
So it's the authority's position that the authority followed the regulations to a T throughout this process?
Yes. Yes, Your Honor, absolutely. And the problem, and we expressed this to them, we expressed them in the informal hearing under the regulations. You first have an informal hearing. If you don't like it, you have a hearing at the Bureau. We expressed at all times that our concern was Brockton Redevelopment has a limited budget. They have to manage their funds appropriately. They're getting it from other government sources.
Stewards of the public, I understand. We've read your papers. I'm just trying to make sure that we're not saying, hey, we get to kind of maybe play a little loose with the regulations, but we're going to hold the furniture mover, the furniture company, who this is not their business. Their business is selling furniture, to the T.
My position, and I believe all the testimony, was Brockton Redevelopment followed its obligations to a T. And it can read the regulations, as can their relocation specialists, as can Brockton Redevelopment's lawyer. And Mr. Abdelmonum said, I got the money from the bank. This wasn't money he was keeping in the mattress. If you're required to provide documentation, give us the bank record that shows that you had each Monday or each Friday on payday, you had a withdrawal from the bank of some amount of money. Then we could say, yeah, it looks like that's what you were doing. He didn't even do that.
Had he done that, would that have been enough? If we just said, yeah, you took out some money, how do we know who you gave it to?
I would have wanted to see what it said, but if it was him withdrawing cash coincident with the times when they were moving, I mean, what can you do? The reality is you're moving. He's not the only person who was in the building. Other people were in the building. They're trying to manage their legal obligations and their financial obligations as best as is possible, considering that people don't get relocated by eminent domain every day.
Do we know from this record when exactly Mr. Abdelmonum found the new site?
We don't, however, we do have a date in Exhibit 13, in front of the Bureau. It's on Record Appendix, page 74. That is the claim form, and that one in which he was working with the relocation people to try to work it out. About 2/3 of the way down the page, there's a start date and an end date for the move, and I haven't recently read all the testimony, but my recollection is he didn't start moving till he had a place to go. In fact, it was a bit of a bone of contention that we needed to get the building vacant to redevelop it, and he didn't yet have a place to go, which is why we were talking about mover quotes to move him into storage while he was searching.
Well, what do we do with the fact that his letter saying he's going to do a self-move is dated April 3rd of 2020? I think we all remember what was going on in April of 2020. And time is money for the Bureau, I mean, for the BRA and for the movers and for the furniture people. If he suddenly finds a place to move to that's available, maybe because of the pandemic, And as he testifies, there's a bunch of day laborers who are available to work for cash.
Nobody questions that he moved it, and he's entitled to relocation payment.
How did
He
they come up
already
with
got
the 80%?
$220,000.
How'd you come up with 80% of it?
I'm sorry.
How'd you come up with 80% of his figure to pay him?
Because it was clear that he was entitled to something, as you said, the furniture moved, and it was an attempt to treat him fairly. The statute talks about fair moving expenses. It was an attempt to treat him fairly in the absence of any documentation.
So 80% was just an arbitrary percentage?
Well, in that sense, it wasn't supported by hard math. It was an effort to follow the statutory obligation to reimburse him for relocation expenses while also not shoveling money out the door with no documentation whatsoever.
Had he chosen one of the 4 bids, the 2 higher ones, would that have been in his right to choose one of those 4 quotes?
We cannot impose the move upon him. So, yes, it would have been in his right to do that.
And so had he selected the highest one, would you have paid more?
I believe we would have, but we also wouldn't have worried that he was making a profit. If it came to our attention that the highest bidder was giving him a kickback for sending him the business, we wouldn't want to reimburse for the full amount. But if that's money expended, that's what relocation benefits are for, money actually expended.
And so it would have been okay had he chosen the highest one, and he came in below that, and we're...
By the way, no surprise with cash day laborers. No surprise that he came in for less. Right. Give us the bank records. He didn't say I had cash lying around.
Did you seek the bank records through some sort of, request for them, a motion?
No, because the way this happens is this is a relatively informal procedure. We didn't know what his testimony was going to be about how he went about doing this. I knew he had used day laborers. I asked him about it. He volunteered that he had gone to the bank and gotten cash.
What did he say before the board's hearing officer?
That's what he said in front of the board's hearing officer. We don't have a transcript.
By the time you got to the hearing in front of the department, you have to have known that he was going to say again he used day laborers.
I'm sorry. When you said board, I thought you meant the Bureau of Relocation. The only transcript we have, and our only knowledge, was that he had used day laborers. The testimony about having gone to the bank to withdraw the money, that came out. It's at page 249 of the record. That's during Mr. Abdelmonem's testimony to the Bureau.
So my question for you is, was the BRA on notice at any point before then that his testimony was going to be he paid day laborers in cash? Did he say that at that hearing in front of the board?
We understood that he had paid day laborers in cash. We didn't know what his bank was, and we didn't know that he was going to say that to get the cash, he had gone to the bank to withdraw the cash. One of the problems in retail businesses is frequently, particularly with some businessmen, they don't want to put their money in the bank, and they are keeping cash in a safe or the like.
He had a lot of mattresses to keep him in.
He had many, and padded furniture. There were lots of places to keep it. We did not know until he testified at page 249 of the record that he went to the bank to do the withdrawals to do so. And it's their burden to document their claim. And they had a lawyer.
If he knows in this relatively informal process.
He may not know, but he was represented by an experienced eminent domain lawyer who's not here today. But that's their choice. They can decide how to do that. The eminent domain lawyer who represented him in front of the Bureau, by the way, also represented him at the eminent domain trial because Mr. Abdelmonem, as trustee, owned the building, and as Brockton Furniture ran the business. Very experienced eminent domain lawyer. He certainly knew what the documentation requirement was, and he had the burden. It was his appeal. He didn't seek to get bank records or any documentation whatsoever.
The we'll have to leave it there.
I'm watching my
You're over.
thing
I think
blinking.
we'll have to leave it there. Attorney Winkler.
Making
Thank
me
you kindly.
nervous. Thank you, Your Honor.
We'll now hear from... Thank you.
Good afternoon, Your Honors. May it please the Court, Grace Golke, Assistant Attorney General, appearing on behalf of the Bureau of Relocation. We are asking this Court to affirm the Superior Court's grant of judgment for the Bureau in this 30A appeal.
Would it have been too difficult to get the bank information?
So I think the issue here is that that's not required.
I understand, but would it have been difficult to get it?
I have no idea, to be honest. We don't know. There's no testimony on that. The testimony that was given by the business owner was that he was acting in a very hurried manner. I think, he described himself as frantic in this moment. We just don't know the details of exactly how those transactions were done. So it's hard for me to say, standing here, exactly how he would get those records, what they would look like. What we do know is that the documentation that was in the record is both the fact that obviously the furniture was moved, everyone agrees, but in addition there were extensive documents about what that inventory involved. There was a 36-page inventory sheet. There were photographs taken both by the commercial movers and by Ms. Brooks. There were the 4 commercial bids, 3 of which were substantially higher than the amount that was claimed. And then we also have the testimony of Mr. Malika, who has 30 years of experience in this area, as well as Ms. Brooks, who was involved in the day-to-day, both saying this was a reasonable calculation based on all of that information about what we know about what had to be moved, what kind of furniture it was, how long that would take, and what was involved. And they found that it was adequately documented, that that in perfect circumstances, you may want receipts, you may want bank statements, but that there's a recognition in this statutory and regulatory framework that the displacing agency, which is the authority here, needs to take into account the special circumstances of people and businesses that are displaced by eminent domain. There's a recognition that this is a case where the state is exerting an important but very invasive power. It's involuntary on the part of the displaced people and businesses, and that they may not have all of the types of documentation that we would expect in other scenarios where someone's engaging with the state asking for repayment. That these are particular circumstances where there's a real equitable and remedial purpose behind the statutory and regulatory framework here.
I got the impression from the papers, and correct me if I'm mistaken, and I may very well be, was that the overall sense I got was kind of what's good for the goose is good for the gander. And if you're not going to adhere to the rules, kind of strictly on the authority side, then how can you now ask the furniture company, who happens to be in this instance, to strictly comply with the same rules and regulations? Is that a fair reading of?
I think that is fair, Your Honor, that the framework here puts an affirmative obligation on the displacing agency, on the authority, to take certain steps to inform individuals in this process about what their options are, how they pursue those options, what they'll need to do to get payment, and that where the displacing agency fails to fully inform someone, it is not fair or equitable to then hold that against them. And that where this scheme is really grounded in fairness, in equity, in trying to prevent closures of businesses, that's specifically in the purpose statement of the regulation, in trying to maintain, the economic activity of the area to ensure that essentially that displaced people and businesses are able to stay on their feet or get back on their feet after this type of really disruptive action, that there does have to be, if the displacing agency and the relocation advisory agents aren't providing certain information, it really isn't fair or equitable to then hold that lack of information against the displaced party. And I think that is different than in some other areas of law where, we do presume that people know the law. In this situation, there's explicit obligations to inform, which is unlike some other areas.
What was the documentation for the disputed $130,000?
So I think the issue here is that the authority didn't explain what its math was. So it didn't explain which expenses it was deducting. It applied this, what it called an 80% reduction, although that doesn't actually add up in terms of the math. So it didn't specify, we're allowing this expense but not this expense, or we're allowing this
But
much.
I'm on the other side of it, on the
Sure.
disputed portion, the 130,000 that was disputed.
So-
It seems that the judge was satisfied that, well, okay, maybe there wasn't strict compliance here, but it's excused. But I'm just trying to understand what was the documentation that's required by the statute for that 130,000?
So the issue, Your Honor, is that we don't know what goes into that 130,000 because of the way that the authority denied the claim. The claim was made for 350,000, give or take. The authority and the claim form attached all of the documentation that was included with that, some of which are receipts, some of which are invoices, and then there's various notes made by Ms. Brooks, I think primarily about, this is reimbursable, this is not reimbursable, there were things that were excluded, so there's all this back and forth, there's that universe of documentation, and then the partial denial from the authority, which I believe is at 117 or 118 in the record, just says, this is the figure you've said for this category, we're only reimbursing this much. And then this is the figure for another category, we're only reimbursing this much. It does not explain which of the expenses it's excluding. And so we can't match it up to documentation.
So we, as a court, cannot tell if the statute was satisfied.
Well, Your Honor, what the Bureau found was that the statute was satisfied entirely. So it found that that entire claim, the $350,000 claim, roughly, I think it's 351 and change, was satisfied because the documentation, which does not only include receipts, it also includes, I think there's a catch-all saying other evidence payments were actually made, which can include things like the furniture was here one day, now it's not.
I understand it, but I'm focused on the language in the statute that says that it has to be documented. So if we're talking just about the disputed amount of $130,000, because that's what's at issue here, it's just the $130,000. So put aside all the other amounts and how calculations were made to get there. Just can we tell whether or not the payment of that $130,000 is documented as required by the statute?
And I would say the Bureau's position was that because the full amount was documented, there was no basis to dispute any portion, and that documentation came in different forms for different expenses, but that based on both the claim form itself and the attached documents, and then also the testimony of Mr. Malika and Ms. Brooks, as well as the business owner himself, that all of that together formed the reliable documentation required for each individual piece of the claim. So there wasn't sort of a line by line, either in the way that the authority denied the claim or ultimately in the Bureau's decision. What you see is that the Bureau looked at the claim in full and found that each part of it was properly documented and properly supported. And
I apologize. So properly supported, I think, was a little bit different than maybe properly documented. But is there somewhere we can look and we know for sure that the labor costs were properly documented? And what documents do we look at for that?
so, Your Honor, the documents I would point the court to are the spreadsheet that's attached to the claim explaining the breakdown. So, how much for each floor, how many days were spent, how many laborers. And then the fact that that then corresponds with the inventory sheet. You don't have the inventory sheet or the photographs in the record, but you have reference to them in the testimony, that Ms. Brooks, in looking at that spreadsheet, said, yes, this is reasonable. It corresponds with what we would expect to see based on a move of this size over this amount of time.
And so I thought I read somewhere that somebody did the math and it came out to about $18.75, I think, an hour for the day laborers.
That's correct, Your Honor.
Is that a reasonable figure for day laborers?
I think there's no evidence that it's not, Your Honor. It's only a few dollars above minimum wage in the state of Massachusetts. And so there's nothing that was put in to suggest that's an unreasonable rate to have paid these laborers for what was described as very delicate work. It wasn't just kind of picking up a couch and moving it. This is fine furniture, which was credited.
Do we know how many hours a day they worked?
I believe it was 10 hours a day. I'm just trying to remember exactly where the form is. And in terms of just how long the move took, I believe the reference to and I can find the sheet as well, but I believe the reference to 3 months was the time that the furniture actually moved from one location to another. But the testimony was that before that, there were many months of essentially consolidating the furniture down onto a lower floor. So there were several months of wrapping furniture and then moving it because of this broken elevator that had to all be done, on stairs.
Preparing it for the move, for the ultimate move.
Right, exactly, Your Honor. So although for example, the U-Haul receipt, there are receipts for the U-Haul trucks. That was in September and October, but that prior to that, there had been quite a bit of work for preparing the furniture.
I have a question for you about the statute and the degree of deference that we give to an administrative agency. So at page 76 of your brief, there's it's the 79A, section 7, Roman numeral 3B, I think, and that says the person who's moved is entitled to review of this claim by the Bureau of Relocation, and the disposition of the Bureau of said claim shall be final. Now, there's a bunch of footnotes in cases where appellate courts have basically said, we're not going to reach that. Do you know of any other administrative agency statute that has that their decision final, and is 30A review appropriate here?
Your Honor, I'm not aware of whether that language appears in other statutes. I think both parties proceeded on the understanding that 30A is the standard, and the decision may be final in the sense that it is the final agency decision, which then goes on judicial review. We didn't make an argument that a different standard should apply, and I'm not aware of any case law on
And there
that.
might be constitutional problems with having it be final.
Subject to some other standard, yes. I think that would be possible, Your Honor. And I was trying to find that spreadsheet to look at exactly how many hours. I know it is cited in our brief, and I'm afraid I can't find it quickly for you, Your Honor. But I would just urge the court to look at both the testimony of Mr. Malika and Ms. Brooks and the time that they spent going through this claim with Brockton Furniture. These are experts in this field. They were hired by the authority to act as their relocation advisory agents, and they said after this extensive back and forth, marking up pages, disqualifying certain expenses, they got to a point where they felt that claim was reasonable, that it reflected the actual payments that were made, and that Brockton Furniture was entitled to that full claim. And in this context where the displacing agency does have this unique obligation to ensure that the process is fair, that displaced people and businesses receive full compensation, they're meant to minimize adverse impacts of displacement. Under all of these various circumstances, the Bureau, I think, here reasonably applied the statutory and regulatory framework to harmonize the requirements on the businesses, but also the requirements on the agency to ensure that the business has the information it needs in order to make a claim for its reasonable and actual expenses, which is what happened here. And I'll just close by saying I think one concern here of the Bureau is that a reversal here would reinstate what was essentially an arbitrary decision by the authority, picking what honestly is just a random reduction, rather than engaging in some, if their concern was lack of documentation, what they could have done was go through line by line, identify items on which they thought there was not appropriate documentation, and engaged in that process. And instead what they did was choose an arbitrary number, misapply the way that that applied to the actual figures here, and that was not in line with the statute's remedial purpose. And so we would ask this court to affirm.
What about the BRA's argument about the judge's discussion about, sort of these equitable considerations and all that, that they really have no place here, that it's really just a question of was the statute satisfied or was it not?
Well, Your Honor, I would point you to one case that I'm afraid was not in my brief, but called the West Broadway Task Force v. Boston Housing Authority. It's a SJC case 414 Mass 394 from 1993. It said the statutory requirements of Chapter 79A are not formalistic but functional. That case was looking at the definition of displaced persons, but I think that that statement stands for this recognition that the statute and the regulations apply to a very specific situation where the state is exerting this extreme power over private property, and that there does need to be a fair and equitable process for ensuring that displaced persons get reimbursed for their full expenses. And so this quote, I think about, it's not meant to be hyper-technical readings that are held against displaced persons and agencies. It's meant to ensure that there's a fulsome process, and I think that did happen here. There was notice of the self-move, there was negotiation with the agents, there was clearly interactions to make sure that the business here was only being reimbursed for what it was entitled to, but that it was reimbursed for the full amount that it was entitled to. And so I think that the statutes and regulations quite clearly do have this equitable purpose that needs to be taken into account in reading the requirements of the statute and regulations.
I see that's your time.
Thank you, Your Honors.
Thank you. Matter stands submitted. That concludes our business for the day. Thank you all. Thank you, court officers.